Each side will have 15 minutes, and the appellant may reserve up to 5 minutes.
If it may please the court, my name is Marco Vaccarelli. I'm with Friedman, Damiano & Smith, and I represent the appellant Lonnie Fletcher. The case we are here today is about an injury in a parking lot of Wal-Mart at 1000 Chestnut Commons Drive, Elyria, Ohio. The issue is whether or not, I believe there are two issues. One is whether or not the area in which my client fell and injured herself should be considered an open and obvious hazard, or whether or not that is an issue that should be taken to the jury for determination. And secondly, there is argument as to the application of the Kimball rule, which has stated that a hazard of less than 2 inches is so trivial as to not be considered a hazard again. Essentially, my client had surgery on her wrists, most recent being in June of 2013, to the extent that she had been trained by her treating physician to be hypervigilant about circumstances surrounding her so as to not jostle her arms or her wrists lest the surgery sites be reopened. Specifically, she was instructed to be vigilant of people around her, specifically shopping carts, cars, and things of that nature. When she got out of her vehicle in the Wal-Mart parking lot, there is no open and obvious hazard when she scans the parking lot one time before proceeding to the store. It appears to be a flat blacktop. As she approaches the store, she is surrounded by moving vehicles. It is a very busy store and a very busy parking lot. Immediately to her right, there is a parked vehicle that has several people out and milling around. Because of that, she is, again, being vigilant in making sure that she is not going to be jostled, not going to be bumped, and not reopen an injured site. From a distance, there is a site that is approximately 21 by 35 inches long and wide, so about 2 feet by 3 feet wide. And the issue of the height of the area in which she tripped, there is testimony that it was 1.5 inches tall, but in fact what we're talking about is a large piece of broken concrete, which is broken into several sections of varying heights to make it more hazardous than just a jutting up piece of concrete. In observing the people around her as she walked forward, she was not particularly looking down. However, the law of Ohio is that she does not have to be looking down constantly in order to observe her surroundings. Her need for hypervigilance is a attendant circumstance in this situation which should be considered.
Doesn't that kind of cut both ways, though, in regard to your argument that she's hypervigilant? Because obviously, if you're instructed to be really vigilant about going out and to make sure you're not re-injured, would that also go to whether or not she should have been looking at the walking area, the parking lot, the terrain, and so forth as well?
Yes, Your Honor. And before I answer, I would like to ask if I could reserve 5 minutes for
Sure.
I apologize. I didn't say
That's
that.
fine, you're fine.
But again, I don't think the arguments will be that long today. Although it could be long. She was specifically instructed to be observant of the people around her by her physician. That is her testimony. On top of that, as I mentioned, I think you'll find the defense argument cuts both ways. They are both looking to argue that this is not an open and obvious, that this is an open and obvious hazard, and that it is a trivial hazard under the Kimball rule. I think that's where it actually cuts both ways. My client did do an observation of the parking lot from a distance, and from a distance, it's not an open and obvious hazard. I do understand certainly the risk or the concerns of Your Honor as to it cutting both ways, but I believe that's an issue of comparative negligence and creates an issue of fact. Along with that, the idea of the attendant circumstance is specifically poignant in this case because although the court may not have it, there's testimony, or rather there's video, but there's also attending testimony that this is an exceptionally busy area, that there is a lot of traffic going on, that there's a lot of people in the needed area. On top of that, and I think that, Your Honor, this will also, you'll tell me this also cuts both ways, but there is knowledge on the part of Wal-Mart that there's this defect in the parking lot. In fact, they had painted it a different color. Now, and again, I understand that that does cut both ways, but again, I believe that that goes to comparative and a question of fact. Should she have been able to identify this, even though she did do a scan from a distance? Should she have been more vigilant of the ground as she approached the store? I would argue that given her circumstances that she should not be.
Was she asked whether or not she noticed that it was painted a different color?
She did not notice, Your Honor.
She was asked and she said she did not.
She was asked what she was aware of as she approached the store, and the only thing that she knew was that she was watching the people and the cars around her, and as she approached the store, she hit something and fell on her face, opening surgical wounds from carpal tunnel surgery. So she does have attendant circumstances which go to the totality of the circumstances and remove the open and obvious doctrine, or at least then towards a comparative question on the open and obvious doctrine. For those reasons, the Common Pleas Court erred in granting the motion for summary judgment. I think, in part, the fine questions asked by this panel, I think, lend themselves very much to the, is there a question of fact? And, you know, the law in Ohio is that you are not required to constantly look down. It is the totality of the circumstances. But there has to be no, and I know that this judicial panel is well aware of the summary judgment standard, but it is no material issue of fact that no reasonable mind can come to any one but one conclusion. And when you look at the intended circumstances in this case, I think it's clear from the very intelligent questions asked by this panel that there are questions of material fact, that reasonable minds could potentially come to different conclusions.
Thank you. I neglected to say, obviously, there are two of you.
Yeah.
At police, so you have to split the 15 minutes.
Right, I'm gonna go for 10 and Aaron's gonna use 5, if
Okay,
that's right.
that's fine.
Your Honors, Donnie Beulah here arguing on behalf of defendant Applee, Wal-Mart Stores East. And I submit to you that the trial court got this case right. As counsel mentioned, plaintiff Bonnie Fletcher fell in the parking lot of the Elyria Wal-Mart on July 12, 2013. Also, as you mentioned, the incident was recorded by surveillance video and the incident scene was captured with color photographs. There's no disputed facts in this case. There's no dispute about what happened. There's no dispute about the condition of the parking lot at the time of the incident. Based on plaintiff's own measurements and evidence submitted, the concrete was raised 1.5 inches, which as a matter of law is a trivial crack, which is not actionable. Moreover, the area was open and obvious. Plaintiff fell in an area that was about 6 square feet. It was painted orange and then outlined in blue paint. So there's no question it was clearly demarcated from the surrounding parking lot area, the photographs of which are all part of the trial record. Simply put, as plaintiff herself testified, the area was out in the open, obvious, and she could have easily seen it had she looked. Nothing distracted her before she fell. So I ask this court to affirm. As I already mentioned, it is undisputed that the area had an elevation change of only 1.5 inches, and as such, the cracked concrete was insubstantial or trivial under Ohio law, under the 2-inch rule that was announced in Kimball.
Well, but that's just a rebuttable presumption, right?
It is, but in this case, the evidence, and I would also take the time to dispute that being insubstantial or trivial under Kimball and open and obvious are mutually exclusive. They're not, simply because height is only one characteristic of a condition anyone can encounter. There's color, obviously, in this case, is the one that sets it apart. So it's not a mutually exclusive doctrine. But the evidence here is undisputed of attendant circumstances. There's photographs submitted by both sides and plaintiff's testimony, and they all show the same thing. There were no cars, there were no pedestrians, no shopping carts, or any other circumstance that would have altered the trivial nature or open and obvious nature of this hazard. It's a position that's supported by precedent in this district. In Gallo versus Karen Asphalt, there was a trip and fall in a retail parking lot on a 2-inch raise in a piece of asphalt that was black and not spray painted. And the trial court held and this court affirmed that there were no attendant circumstances or other conditions to negate either the open and obvious nature or the trivial nature of the crack, or the lip in that case. And even if somehow plaintiff got beyond the trivial nature of the condition, Wal-Mart had no duty to warn or protect her of an open obvious danger, which in this case it was one that plaintiff could be reasonably expected to discover and protect herself from, especially someone who, as the undisputed evidence shows, was being hyper-vigilant per her doctor's orders.
I will say, it does seem kind of weird in the law that you can say something is so trivial that it doesn't matter, but it's open and obvious nonetheless.
Right, well, I think that there's different reasons for the doctrines. I think a trivial defect, as I said, deals with one aspect of an elevation change, whereas open and obvious looks at the much bigger totality of the circumstances. So I think that they're two separate doctrines, but paradoxical might be a way to describe
I just don't understand how something can be so infinitesimal, basically, that it doesn't matter under the law, but yet people are charged with it being open and obvious.
Well, I think I think it's an interesting question, maybe one that a law review article could be done on.
I think there already have been, but, and I think they say that's crazy.
Yeah, I think that commentators have opinions on both sides, but I think the Supreme Court's clearly upheld both doctrines and said that they're not mutually exclusive. And, getting back to what I was saying about the open and obvious nature, I mean, you really look at two things. The courts, as you know, look at two things, the condition itself and then the attendant circumstances. And here, there's no dispute about any of that. And when you're looking at the condition, the testimony that the counselor mentioned, I challenge you, is not in the record. She clearly testified that she could have seen it, would have seen it, looked down, and in her own words, it was obvious and out in the open. So I don't think there's any dispute about the condition itself. And then as far as the attendant circumstances, I think what counselor and certainly in the appellate briefs, the point that they miss is they use a subjective analysis of what the plaintiff was doing here. That's not the correct analysis. The courts, including all the courts in this district and all of them since Armstrong versus Best Buy, have continually said is you have to use an objective test. What would a reasonable person experience under the circumstances? And here, there's no dispute, as I said. It was a sunny, clear summer afternoon. Plaintiff was walking through a parking lot with no objects, vehicles, or anything obstructing her view. From the time she exited her parked car until the time she fell, she did not encounter a single person. She didn't encounter a car, and she didn't encounter any shopping carts or any other distraction. So, again, there's nothing here, and all that's clearly in the deposition testimony. It starts at about page 90 and goes to about page 96, that a reasonable person here would not be distracted. And the case law that's relied upon in the briefing, obviously they plucked 4 or 5 cases that show different situations where attendant circumstances have created genuine issues of fact. But in all of those cases, the circumstances were much different than they are here. For example, in Collins versus McDonald's, there was a group of people walking right in front of the plaintiff and indeed talking and almost involving the plaintiff in the conversation. And the court said a reasonable person could be distracted by that. In Nura versus Goodwill, the plaintiff was pushing a shopping cart full of items that blocked her view from where she was walking. Again, if that were the circumstance, maybe there could be a disputed issue of fact. during Hendrickson versus Miami, you have, graduation day at the University of Miami, Ohio, and a bunch of people jammed on one sidewalk filing into Millette Hall. Clearly, when there's body-to-body people, there's a different set of circumstances than we have here where, there's no factual dispute. The photos, the testimony all show there were no attendant circumstances that would have distracted a reasonable person. So, in my opinion, I think the trial court got it right on multiple grounds. There's the trivial aspect and the open and obvious, and both should be affirmed. And finally, I just want to make one statement about an argument that the co-defendant Moyer raised in the response brief, which Wal-Mart didn't get a chance to reply to. And that's that they should be dismissed from this appeal because Wal-Mart didn't appeal the court's order granting their summary judgment. And we feel that's without merit. One, because there was nothing to appeal. It's a contingent claim for indemnity and contribution. There was no judgment or finding against Wal-Mart, and so there was really nothing to appeal. And secondly, the trial court's order here reveals that there was no analysis, consideration, or decision about the third-party complaint for indemnity and contribution. And under the 9th District case law, Guapone versus Envirocoat, which is 2009, Ohio 5540, this court held that when a trial court does not make a summary judgment determination under Rule 56, there is no determination for review. And that's consistent with Murphy v. Reynoldsburg in the Ohio Supreme Court, which says an appellate court cannot consider legal arguments in the first instance that weren't considered below. It would deprive the non-prevailing party, here in this case the third-party plaintiff, Wal-Mart, of an appellate review. And therefore, because the trial court didn't analyze or make a summary judgment determination with regard to those issues, should this case be remanded, which, again, I submitted and requested it not be, Wal-Mart's third-party complaint should be revived as well. So with that, I thank you for your time today.
Thank you.
May it please the court, my name is Erin Kelly and I represent the appellee and third-party defendant Moyer Industries. Our argument today is twofold. First, we argue that the plaintiff does not have standing to bring this appeal against Moyer Industries. And in the alternative, if this court finds that it does have proper standing, we ask that the court affirm the trial court's decision to grant our motion for summary judgment and dismiss the third-party complaint against us. Contrary to what Attorney Beulah just argued, I do feel that the trial court did do analysis on our third-party complaint. In our motion for summary judgment, we specifically argued two reasons why the third-party complaint should be dismissed. First was that the plaintiff was unable to prove her claims against Wal-Mart stores, and therefore there could be no valid claims against Moyer Industries. We also argued that Moyer Industries had no notice of the alleged defect in the Wal-Mart parking lot, and I think that was supported by the testimony of our 30B5 representative as well as Wal-Mart's 30B5 representative. The trial court did grant our motion for summary judgment and dismiss the third-party complaint against us. And Wal-Mart stores never filed an appeal or cross-appeal from that decision. Also, it should be noted that appellant never made any claims against Moyer Industries directly. It never claimed a separate cause of action against Moyer Industries for negligence, and it never sought any damages from Moyer Industries. It was Wal-Mart who added Moyer Industries as a third-party defendant months after the appellant filed its complaint in the trial court. The appellant never amended her complaint to make any claims against Moyer Industries pursuant to Civil 14A, which provides that a plaintiff may assert any claim against the third-party defendant arising out of the transaction or occurrence that is the subject matter of the plaintiff's claim against the third-party defendant, or third-party plaintiff, I'm sorry. And in this case, the plaintiff never amended her complaint to add any claims against Moyer Industries, and therefore we do not feel that, that the appellant has any standing to bring this appeal against Moyer Industries. In the alternative, if this court does find that the plaintiff does have standing to bring this appeal against Moyer Industries, we would reiterate the arguments that Attorney Beulah made about the open and obvious doctrine and the Kimball rule, as well as we would also argue that the appellant has failed to prove proximate cause. She admitted in her deposition testimony that she is unaware of what caused her fall, and that she made an after-the-fact assumption that the alleged defect caused her fall. And I think that can be found on page 57 and 96 of her deposition transcript. Therefore, the appellant failed to adequately demonstrate that the raised concrete in the parking lot was the proximate cause of her fall. Therefore, we respectfully ask that this court either dismisses from this appeal or from the trial court's decision dismissing the third-party complaint against us.
You have your 5 minutes left.
Thank you, Your Honor. Trying to make some order of the way in which I respond to everything, but I guess maybe reverse order will be the easiest for the purposes of this. There was two major issues, one being whether or not we were able to bring an appeal against Moyer, or whether or not the complaint against Moyer should be reinstated. The whole basis of the granting of the summary judgment is that there was no proof for us, allegedly no proof that we could bring our claim against Wal-Mart, therefore the claim against Moyer failed. In the instance in which this panel were to reinstate or to decide that the common pleas court erred, it must be reinstated because the basis for which the motion for summary judgment was granted, the underpinnings of that decision have fallen apart. As it relates to the proof of this defect causing the injury, case law would support that there is no need for direct proof of the defect causing the injury, but I would actually just go back to the old adage that you're taught in probably your first year of law school, is that if snow falls and there's footprints on the ground when you wake up in the morning, there is circumstantial evidence that you have had a visitor in the night. I believe that that is the testimony that a reasonable jury could reach, that there is a defect in the parking lot, that my client tripped and fell immediately at the area of that defect. I don't think any further proof is necessary, and that a jury can make a determination on that circumstantial evidence that the defect was the cause of that fall. I would also point out that Wal-Mart was well aware of the defect in the parking lot, the orange paint, which is not visible from a distance. And I don't believe that what I was arguing earlier is actually in conflict with what counsel for Wal-Mart was saying. What I said was that from a distance, it was not, she did not see it. I don't try to argue that it wasn't obvious when you're on top of it or when you're nearby it. What I said was that she was paying attention to other things after doing a scan of the parking lot, getting out of her car. I don't think that there's an argument that if she looked down, she would have seen it. However, again, you are not constantly required to look down. You have to acknowledge the totality of the circumstances, and that's Nora versus Goodwill, that's 9th District. I think that there is a clear discrepancy in arguing both open and obvious and the trivial nature of a defect. I don't think the two of them make logical sense. And I would go so far as to argue, which I may already have done, which is that those two arguments in and of themselves create a question of material fact.
And the trial court acknowledged that in the entry, that, but then said, this is the law we have in the state of Ohio, so
Well,
we're bound by it.
Your Honor, I would, it's interesting that you would say that because I intended to read from the judgment entry. I do agree that that is what the entry said. However, I believe that the attendant circumstances allows for an opportunity to look at the totality, which has been accepted by many courts. And the fact that the facts are different in each of those cases only lends itself to the fact that this is a acknowledgement that you have to look at the totality of the circumstances and there is questions of material fact. There is not going to be a singular attendant circumstance which is going to apply universally.
I thought I understood gentleman over here to say that there were no people and there were no cars in her immediate.
I would disagree with that wholeheartedly. Both the video, there is video which is part of the record which shows that there is a vehicle immediately to my client's right as she falls. There are people outside of the
It
vehicle.
was moving, the vehicle was driving.
The vehicle immediately to her right was actually not moving. It was parked, but there were people getting in and out of that vehicle. There was quite a number of people, I'd say 4 or 5. And in addition to that, we're talking at the area which is the cross section right across the front of the store. It's right by handicap parking. So that's where you're going to have the most traffic. People going across the front of the store, people coming around that turn in order to turn into a parking lane. All of those are the things that at that immediate area is what was concerning Ms. Fletcher. And to go back to your question, and I understand the final ruling of the court, I just think that it was not viewed in the totality of circumstances as perhaps it should be. But the court actually cites Justice Pfeiffer from Armstrong versus Best Buy. And Justice Moraldi quotes saying, "We've all tripped over something left on the floor by our children, spouse, roommate, or even ourselves. Many times the item tripped over is in plain sight, open and obvious. Nevertheless, we trip because we don't see them. Open and obvious dangers are not always seen, and a jury is capable of determining whether the person not seeing an open and obvious danger was wholly, partially, or not at fault. The open and obvious danger doctrine is a misnomer, and its use as a complete defense ought to be abrogated. My apologies. The inquiry about whether a duty is owed in this context should be premised primarily upon whether the defendant has created a foreseeable risk of harm to the plaintiff, not solely on whether a risk, if seen, should have been avoided." I think.
Cancel your out.
Oh,
I didn't want to stop you in the middle of that quote from the court. Okay, you're out of time.
thank you.
Thank you both. Thank you for all the parties. We will take the matter under advisement and issue a written opinion that will be sent to everyone, as well as releasing it on our website, of course, and the Supreme Court's website as well.
Thank you.
Have a good day.